All right, good afternoon, folks. We're going to give people just a couple minutes to get logged on, and then we'll get started with our town hall. And I appreciate everyone's interest and for joining. All right, we'll go ahead and get started. This is a town hall about the CIRT investigation that stemmed from a February 18th, 2023 critical incident response team investigation that occurred up on North I-25. This is the first town hall that we are doing on a CIRT investigation. Our intent is to do these on all CIRT investigations after the conclusion. We think that you all, the community, has the right to be informed and engaged on what this process is, because the district attorney's office, as well as all the law enforcement agencies that participate on our CIRT team, are very cognizant that these are incredibly important investigations, that they're of the utmost community concern, and we want to be accountable to you all. So this is a new process we're starting for 2023, and this will be the first one. So we appreciate you all's interest. As it says at the bottom, if you do have questions, you can put those in the Q&A, and we have someone collecting those, and I will do my best to answer those at the end of the presentation. There may be some questions that are very detailed, and we may have to look into those and try to get back to you. If that's the case, we'll also do our best to follow up. So first, we're going to give an overview about what a use of enforced investigation is and why we do those here in Larimer County. So some of that is governed by statute. It requires that investigations regarding discharge of a firearm that result in injury or death, or other uses of force that result in death, be investigated. So it's a pretty narrow subset of officer use of force investigations, and it requires the participation of at least one other law enforcement agency. And then it also requires, on that narrow subset of cases, myself, the district attorney, to issue a report about those. Our 8th Judicial District protocol goes far above and beyond what those legal requirements are. We have had a CIRT, which stands for Critical Incident Response Team, process in place in some form since 2005, which is well earlier than many other jurisdictions. It's been rewritten several times. Most recently, we did a collaborative rewrite in 2022. Every single law enforcement agency in Larimer County participated in that rewrite and participates in our processes. So this is an effort that everybody is engaged in for the benefit of getting unbiased and thorough answers for the community. The purpose of the CIRT is to be very well-resourced, very thorough, and very transparent. And so we are trying to provide the public with the most information as possible. One thing you'll probably hear me reference throughout this presentation is that there's a written report that precedes these town halls. And in this case, that was published about 10 days ago. That is on our website. I hope everyone here has had an opportunity to read that, because that report is much, much more thorough and more detailed about the facts of this case than we would ever be able to explain through a town hall. So this town hall is not trying to replace that report. If you haven't had a chance to read it, I encourage folks to go back afterwards and do that. And we realize that to build trust and to be accountable to the community, we need to provide every opportunity. So while the law just requires a report, this town hall is a chance to go above and beyond that to make sure we can answer every possible question that you all may have. So our CIRT process here in Larimer County includes all of the above things that, again, are above and beyond what the statute requires. A lot of these are what we call discretionary cases, meaning the law does not require them. We recognize here in Larimer County that our community expects that these be treated in an independent manner with outside investigators looking at them, with the DA's offices reviewing them. So this is a very broad group of cases. These have been consulted on by our CIRT team, the commanders, and myself, the district attorney's office, for probably going on about a year now, so that you all can know that there are eyes independent eyes on this broad subset of cases. After an incident occurs, there's a consultation among CIRT commanders and myself, and that consultation determines what resources may be needed. In a case like today's case, where there was a death, that is a full CIRT investigation with an enormous amount of resources dedicated to it. In other situations, there might be somewhat fewer resources dedicated to it as the situation necessitates. Our investigation involves multiple agencies, and it involves an independent agency leading that investigation. So Colorado law only requires a different agency to be involved, but we believe the spirit really is that an independent agency needs to be leading it. In this case, that was the Fort Collins Police Department. It lists the goals there. The goals are to be thorough and accurate, to provide an unbiased review, and to provide enough information for the district attorney's office, myself, to make charging decisions about officers who are involved, and charging decisions about citizens who may be involved in that same incident. Then that case, at the conclusion, is presented to the district attorney's office. We then decide whether charges can and should be filed pursuant to the Colorado law that would govern those. And again, starting this year, we're also going to be holding town halls. Our CIRT protocol is posted on our website. It is a very long and in-depth protocol. Again, like the letters, much more extensive than we would want to present to you here in the town hall, but I'd encourage folks to go look at that. It outlines the roles and responsibilities of all of the involved parties, all of the involved agencies, and how that plays out. We believe that having a sort of regimented system is really going to provide consistent and fair results that you as the community can count on, and that has served us very well in that regard. So what is my decision based on? My decision as the district attorney is based first and foremost on the rule of law. There are criminal standards in Colorado that govern what officers' authority is and when those officers can be charged. It is separate and apart from civil actions and other things that are not criminal. I then apply the law to the facts. So the facts of every case are incredibly specific. Again, as you can see in the report that we issued, the Fort Collins Police Department and the other assisting agencies collected an enormous amount of evidence in this case, and we reviewed all of that. Ultimately, my decision in any criminal case, whether it's a CIRT investigation or any other case that we screen here at the DA's office, is whether there is a reasonable likelihood that the evidence supports a unanimous jury decision beyond a reasonable doubt that someone committed a crime. And so that's the ultimate question we must ask ourselves. What we can't do, and this is important too, because a lot of folks often have questions and have already asked us questions on this case. Why didn't you fire the officer? Why didn't you require the sheriff's office to do X, Y, or Z? I understand those questions, and those are fair questions, but we don't have the authority to do that. So the district attorney, neither myself or any other district attorney has the authority to discipline or fire an officer. We cannot change what any law enforcement agency is doing for training or policy. We cannot change what the law is. And sometimes we get folks who disagree with what the standards are for police. Those can be fair disagreements. Reasonable people can disagree, but that's not something I can change on any individual case. I also don't have the authority to impact a civil lawsuit. So we often hear about civil lawsuits in these types of cases. Whether that occurs here or not, I don't know, and is beyond our scope of authority here at the DA's office. So there is an officer use of force statute in Colorado that governs very specifically when an officer can use force, and if they do, how so. This is just a small part of that statute here in this slide. It's the first part and one of the very relevant parts of that statute. It says, again, in part, peace officers in carrying out their duty shall apply nonviolent means when possible before resorting to the use of force. A peace officer may use physical force only if nonviolent force would be ineffective in affecting an arrest. Relevant to this investigation too is also deadly physical force, which says force, the intended and natural and probable consequence of which is to produce death, and which does in fact produce death. And I'll get back to that in a minute, though our conclusion was that legally, Though tragically, Mr. Thompson died in this case, it was not a deadly physical force case as Colorado law defines it. One of the statutes that we analyzed very closely in this decision was criminally negligent homicide. Because if the deputy were to have been charged in this case, that would have been a charge that one would want to have considered. We did consider that very closely. We put the definition here on the slide. Any person who causes the death of another by conduct amounting to criminal negligence. Now, criminal negligence is separate and apart from how we might use negligence in our ordinary discourse. People walking up and down the street using the term negligence, that applies in a very different manner than criminal negligence. And that definition is very specific, and we put that on this slide. It says a person acts with criminal negligence when, through a gross deviation from the standard of care that a reasonable person would exercise, he fails to perceive a substantial and unjustifiable risk that the result will occur or that a circumstance exists. So that is important, very important, and we'll get back to that to our ultimate analysis of whether this case can be proven beyond a reasonable doubt. Because again, this is a higher standard of negligence, this criminal negligence definition, than we would use in ordinary course or even that the civil system would use. The U.S. Supreme Court has also issued some guidance about how to consider officer uses of force. You can read some of that there. Essentially, it says that we must take into account all the attendant circumstances which are occurring and what are often, and certainly in this case, rapidly unfolding circumstances. What do we review? So we review an awful lot because the CIRT team investigators collect an awful lot. They try to turn over every stone because they want to make sure that they're getting the best possible set of information to present to us so we can make the most informed decision possible. A lot of this is things that we review in many cases, body-worn camera, reports from officers, witnesses. Even what is in our report is just a part of the enormous amount of evidence that Fort Collins Police and the CIRT team collected in this case. And again, I believe it was very thorough, and I believe every question that could be answered in this case was answered. So what decisions did we end up making in this case? And again, we're not going to give a whole factual recitation of everything here. I'd refer everyone back to the letter. But first, we concluded this was not a deadly physical force case. I understand that does not ring true to some folks, that because Mr. Thompson died, this should be deadly physical force. That's not how Colorado law prescribes deadly physical force. We provided that definition earlier because this was not a natural result or intended result of using a taser. This was not per statute deadly physical force. And that changes our entire rest of our analysis in terms of how we evaluate the justifications by which the deputy used the force he did use, which was a controlled electrical weapon. Then we asked, was the force legal? And there were multiple parts of that. Those come from that officer use of force statute we referenced earlier. The most important of those prongs to this investigation was likely, was the harm to others minimized? That was a difficult question in this case, because the degree of force used, the taser, is a type of force that law enforcement uses fairly frequently and uses with almost none or no physical harm in the vast majority of cases. The result in this case, of course, was the death of Mr. Thompson, and it was a tragic and unfortunate result. We also had to consider the fact that when the statute says was harm to others minimized, others is not solely Mr. Thompson, though it is important whether harm is minimized to him as well. Others include everybody in the community. And so in this case, others included anyone that could have been on I-25, which were many members of our community driving that evening. We also considered the fact that the deputy in this case was legally permitted to use force to arrest. I may get to this in a minute in a slide, but the investigation showed very clearly that Deputy Lujan did have probable cause to arrest Mr. Thompson, likely on multiple charges at that point, and was still investigating other charges. So there was reason to arrest Mr. Thompson, and the deputy did have the authority to therefore pursue that. And that's that first bullet point. We also considered this was a rapidly unfolding situation. This occurred at night. There's little, if any, lighting out in that section of I-25. The embankment that Mr. Thompson ran down and the deputy chased him down was very steep with very uneven footing, and it was a difficult pursuit for the deputy at that time. We considered as well that this apparently is the first time that a taser has been deployed incapacitating someone in a roadway, and then that person was ultimately killed by other means, in this case, a passing vehicle. That is the determination of the CIRT team, and in consultation with the taser manufacturer, who manufactures most tasers in this country, that this has never occurred before. And so taser does not train on that type of situation, and therefore most law enforcement agencies, including Larimer County Sheriff's Office, did not train in that specific situation. And that is an important factor when we're determining what the normal standard of care that the law would require that deputy to have would be. Our burden ultimately, and we considered, is to prove that criminal negligence standard unanimously and beyond a reasonable doubt. And our final determination was that that could not be met. I've included some of the deputy's specific language here. There's much more of that in our written report, but I include this to show that the deputy's intent does seem clear, not just from his own recitation included here, but from other corroborating evidence in the case, was not to harm Mr. Thompson and was not to incapacitate Mr. Thompson in the roadway, but instead was to protect both Mr. Thompson and the motoring public that evening. And that does seem clear. That was his intent from the beginning. Also, the investigation showed that judgment was wrong. It was incorrect. He obviously did not end up protecting Mr. Thompson, and that result is tragic. It should not have occurred that way. However, that does not mean that the burden for criminal charges is met. I want to be clear that the inability to criminally charge does not mean that the action was correct. It does not mean it was appropriate. It does not mean that I or this district attorney's office approve of it. And it does not mean that there were not other alternatives. So this is not any sort of approval of the actions. My decision is not whether something was right or wrong in our normal parlance. My decision can only be legally whether I can charge that crime and prove that crime beyond a reasonable doubt. These are also the standards applied to every citizen. So many folks don't know what the process for charging cases is. It's similar in every case. Law enforcement presents an investigation, and attorneys in this office analyze that evidence. They look at the law, they apply the specific facts, and they decide whether it can be proven beyond a reasonable doubt. Many, of course, also raised questions about the decision-making, which I understand, and they raised questions about better training, which I also very much understand. I hope that we can all work to ensure that something like this is never repeated. It was a tragedy, and my heartfelt sympathy goes out to Mr. Thompson's family on this case. But those are separate and apart from whether there is a legal basis to file criminal charges. I do want to thank the CIRT investigation team. I do believe this was a very thorough and unbiased investigation into these actions, that we received the information we needed to make a decision. In this case, I would again refer people back to that opinion letter that is on our website. The link is there, but if you just Google Larimer DA, you can navigate pretty quickly to our critical incident response page, read that letter as well as the other letters we have issued. I also want to thank those who attended today. When folks are paying attention to their community and what's going on, we're a stronger community. As your government officials, we want to be accountable to you all, and we appreciate your engagement. Whether you agree or disagree with this decision, these forums are essential to that communication between us. So I'm going to take a brief moment here and look to see what questions have been submitted, and then I'll come back with you. So there's a Q&A. We're looking at that right now. There might be a couple hands raised. If there are a couple hands raised, because of the webinar format, it's easier just to put those in the Q&A. So if you wouldn't mind doing that, that would be terrific. Thank you. So we had a question about the timeline of these investigations. So every investigation, whether a critical incident response team investigation or any other criminal investigation, can take hours, can take days, it could take months or years. It depends on where the evidence leads. This case, there was significant follow-up done by the CIRT investigation, and some things that take a long time, even things that are out of our control. For instance, in this case, there was analysis by the taser manufacturer of the timing of those devices. There was, toxicology screens on Mr. Thompson. There's more information about those in the report. Eventually, those all come to us at the district attorney's office, and then we need to wade through all that evidence. In this case, as I said, there was mountains of evidence reports, expert reports, and we wanted to make sure that we did our due diligence and went through all of that very thoroughly. We then staff those cases internally here at the district attorney's office among our administration, making sure that we have thought out every possible reason to charge someone, every possible reason not to charge someone, as we do in every case, and ultimately make a decision about whether we believe we have a reasonable likelihood of success or not. These CIRT investigations, as I said earlier, are incredibly important. So this is not something where we talk about it for 10 minutes and make a decision. We talk about it for hours and days and months and make sure that we are getting it right. So efficiency is always important. We try to be efficient in everything we do at the DA's office, but getting a decision correct is our ultimate and most important goal. We had a question about the sort of appropriateness of the pursuit to begin with and how that bore on our decision. So certainly we've had some questions about whether law enforcement can or should be chasing someone for what was a nonviolent offense. Very clearly, the deputy had the legal right to do so in that case. There were several offenses he had probable cause for. He tried to place Mr. Thompson under arrest. Mr. Thompson then chose to flee, and Mr. Thompson chose the direction to flee towards the interstate. Could or should the deputy have called off that pursuit at some point? That is not the question that we are analyzing here in terms of whether he committed a crime. Because while he certainly could have called that off, he did not have the legal obligation to do so by any means. So our analysis was simply on whether a crime was committed at the point where he used force. The propriety of the pursuit is a somewhat separate question. Those are good questions and questions that as a community, this case aside, we should be having in all situations about when and where we would like our officers to pursue. But certainly the deputy in this case had the right to be doing so in this case legally. Thank you all for bearing with us. A lot of you have had good questions that are lengthy and nuanced, and I appreciate that. So we're trying to make sure we're getting you the right answers. We had a question about did the deputy act correctly, is the word used in the question. I think I have said that, if not in this presentation, in the letter. His decision with hindsight was obviously incorrect. The deputy's intent, I think, was very clearly to prevent harm to Mr. Thompson and the public. In hindsight, which the deputy obviously did not have at that time, he did not prevent that harm. And unfortunately, Mr. Thompson lost his life because of that. It should not have happened that way, but that is separate from the criminal standards. The follow-up to that was, what should the training be, or should there be training? I also mentioned that in the letter. I absolutely believe training should change. I hope this was a wake-up call for the taser manufacturer to change their protocols and how they sort of train agencies to train. And they work nationally to bring this to the forefront of those using tasers so that they are aware of this type of situation. So I absolutely believe that law enforcement agencies can benefit from this case and hopefully preventing it from ever happening again. We received another question about whether it should have been, quote, obvious to the deputy that result would have occurred? That is a very complicated question and a difficult question, frankly, to answer. There's much more information about our thought process in that in the letter. Briefly, I will say the split-second decision-making that was occurring in a challenging environment in that case made it less obvious than any of us would think in hindsight. I will tell you that we did a scene visit. I personally stood at that exact location on I-25 and observed traffic. We go into this in the letter somewhat. And Fort Collins Police accident reconstruction experts who also did a full accident reconstruction in this case, drove up and down the highway. Those vehicles coming from that distance are difficult, if not impossible, to see from where the chase or the pursuit began. And obviously the intent of the officer was to take Mr. Thompson into custody before the roadway. Now, that's not what ended up occurring, but that result was one that he faced many challenges in assessing accurately, as we now see in hindsight. Further, Deputy Lujan was also weighing, as an officer always is in the use of force, the potential risks of a use of force versus the potential risks that they are mitigating. And while, again, his judgment may not have been the correct one, Deputy Lujan certainly was attempting to mitigate legitimate risks. That is the risk of someone who he suspected at the time to be impaired when he pulled him over. And the deputy was correct in that assessment. Mr. Thompson was significantly impaired by fentanyl, which is shown by the toxicology report. And so he was trying to prevent someone he suspected from being impaired from running in an interstate. And certainly that presented a real and significant danger to innocent members of our community. So whether he got the analysis perfectly correct in that split second is not as obvious as it may seem without looking into some of those additional details. Okay, it looks like we've answered all the questions that came in. If anyone has any last questions, we will get to those if they're in the next few seconds here. Otherwise, you can always contact our office. Our contact information is on our website. We have an email and phone number on that website, and we will do our best to follow up with people that contact us through those means.
There's one more question coming from Cole.
One more question might be coming. We'll see to answer that. I also encourage anyone, if there is questions or comments about how we can be effective in informing you all as the public through these town halls. Again, as I said, this is our first one, and we're doing these to try to engage and be accountable to y'all. So if there's things that you want to see in these that you did not today, or things that you saw that you appreciated, please let us know, and we'll try to be more responsive to you as we go on. Okay, so the last question is essentially, if the decision was wrong and there's no criminal punishment, what's the community's recourse? That's a very good question, and we touched on some of those things. Obviously, there are, first of all, a sheriff's office that is the involved agency here and the employer of that deputy. I certainly don't speak for Sheriff Fain in any regard. But I certainly know that he tries to be very responsive to the community. And so to the extent folks have questions for the sheriff's office about whether it's officer discipline, whether it's training changes, whether it's protocol and policy changes. I would certainly encourage people to reach out to the sheriff's office and ask those questions. I would imagine that they would try to answer those questions for you. Folks also always have civil remedies. Whether that is a remedy someone will pursue or will be successful in this case, I do not know, because again, our authority is only criminal. The sad situation often in a district attorney's office, not related specifically to CIRT investigations, is that there are tragedies for which there are no appropriate criminal charges. And that doesn't mean that a family's grief is any less or that community concern isn't appropriate, but not every tragedy is appropriate for criminal charges. And that's the situation here as far as our scope of authority at the district attorney's office. All right, well, that's the final question. So thank you all very much again for participating. Again, I very much appreciate your engagement, and I hope you have a nice rest of your afternoon.